Hello, everybody. Welcome to Legal Aid Service of Collier County. This is a lunch bunch webinar dealing with evictions during the time of COVID. Legal Aid Service of Collier County is a nonprofit law firm. We serve the Collier County community. We'd love to help people with civil legal problems, and I hope that you always look to us as a resource. Today's topic is, like I said, eviction, and we'll get to that in just 1 second, just a few housekeeping types of things. Spanish translation is available for this webinar. Just look for the button on your screen. We are also live streaming this on Facebook. We're recording this presentation, and it will be available on our website later on. Everybody in the audience is on mute. We aren't using video view, so we can't see your lovely smiles. We'll just trust that you all are looking great today. I guess that's it for the things I had to say at the beginning. So let's just go ahead and get started. I just got to bring up the presentation.
There you go.
Okay. Thanks for everybody's patience. I appreciate it very much. Evictions in the time of COVID-19. My name's Kathy Lucrezzi. I'm a supervising attorney at Legal Aid Service of Collier County. And one of the things that I do at Legal Aid is defend people in evictions. The situation with COVID-19 has presented some particular unique circumstances that we're going to go over today. So this webinar is going to focus on two sources of law. One is an order that came from the Centers for Disease Control. And this is a very unique and special order. We'll get into great detail about it in just a bit. And of course, we're going to be relying on the Florida law dealing with landlords and tenants. First, a couple of basics so we're all on the same page. A rental agreement can be oral or it can be written. It's better if it's written because then there's no dispute over what the agreement is, but an oral agreement is also enforceable. The rental agreement should list the address of the property. It should say what the rent is and when it must be paid. And it says when the tenancy begins and when it ends. Again, you know, it's great to have all this in writing so there's no dispute later on. But even if you just have a handshake of an agreement, it can be enforceable. The term of the tenancy is an important part of the lease or the rental agreement. Many written leases have a beginning date and an end date. And if you've got a written lease, it'll say on there, begins September 1, 2020, and then it'll say ends August 31st, 2021. That's very typical. But if the written lease does not have a beginning date and end date, then the term of the tenancy is figured out by how often you pay rent. So if you pay rent monthly, then you've got a month-to-month term. If you pay rent every week, it's a week-to-week term. So why is this important? It's important because if you know the term of the tenancy, you know what the expectation is of when you have to move. At the end of a lease, in most situations, you have to vacate. Usually there's no automatic renewal. If the landlord lets you stay, beyond the end of the term of the tenancy, that's great. Then you're starting a new tenancy. Maybe it's a month to month, maybe it's a week to week. But you always want to know what the term of the tenancy is so that you're not caught unawares. For most landlords in Florida, the landlord has no obligation to renew the term of the tenancy. At the end of the rental agreement, the landlord can choose not to renew. That's true for a lot of properties, not all. If it's a property that is covered by Section 8, or it's public housing, or it's what's called a tax credit property, then some different rules apply. But let's get into the order from the Centers for Disease Control. So the Centers for Disease Control issued an order on September the 4th of this year, an extraordinary order that is unlike anything I've ever seen. Basically, it puts a hold onto evictions, a hold on evictions until December 31st, 2020. But there's certain qualifications that have to be met. It protects tenants from eviction based on non-payment of rent. Only non-payment of rent. A tenant who's being evicted for other reasons is not protected by the order. And it's not automatic. So the order from the Centers for Disease Control does not automatically stop evictions. Instead, you, the tenant, have to take some action to make the order work for your benefit. And that's what we're going to talk about next. For the CDC order to work, you have to give a written declaration to the landlord. And this written declaration is something that is required by the Centers for Disease Control. And it has 7 criteria. If you can fit into all 7 criteria, then the landlord cannot take an action to take you out of possession of the rental premises. They can't evict you. But you have to meet the 7 criteria, and you have to put it in writing and give it to the landlord. So let's go through the 7. Now, the first one is rather straightforward compared to the others. You have to swear that this is true. I have used best efforts to obtain all available government assistance for rent or housing. And I'm going to translate that into something other than legal talk. And it basically means you tried to apply to the government for money to help with rent. You don't have to be successful, but you have to be able to say that you tried. You tried to find some money out there that would help you pay the rent. The second criteria deals with how much income you have in your household. I'm not going to read the details of it because it's very confusing, but again, I'm going to try to put this in plain speak. You qualify for the CDC order protection if you earned less than $99,000 in 2020. And I don't know about you, but that covers a whole lot of people, includes me. Or you didn't have to report any income to the IRS in 2019. You know that your tax return was due into the IRS usually in April, but it got extended because of COVID-19. But if you didn't have to report any income to the IRS in 2019, then you fit under the CDC order. Or you got a CARES Act stimulus check this year. So if any one of those 3 things applies to you, so these 3 things, You don't have to meet every one of them, but at least one of them you have to fit under. Then the third criteria is that you've had a reduction in income. Maybe you lost your job, maybe someone in your household lost their job and they helped with the bills and things like that. But basically, you have to be able to say that the reason you can't pay your rent is because your income got smaller. You lost work, you got laid off, or you have huge medical expenses. Then the fourth criteria says that you're trying to do your best to make timely partial payments to the landlord. And what that really means is you're trying to make the payments, but you can't make it because you have to buy food, medicine, other things that your family needs. So if your rent, let's say, is $1,500 a month, and all you've got is $200, and you try to pay it to the landlord, and either he doesn't want to take it or he takes it, but he says, oh, you still owe me $1,300. That's true, but you're trying to make as best you can, trying to make the rent payments as best you can. Then you have to attest that if you became, or if you were evicted, you would be homeless, or you'd be forced into a situation where it would be overcrowded housing. Basically, you have to be able to say, I have nowhere to go. That's very true for a lot of people. If you don't have the money to pay the rent to the landlord where you're at right now, it's especially difficult to find another place where you have all the upfront money to pay, plus you have to pay that rent. The sixth criteria is really something that will show that you understand how the CDC order works. And basically, know that the rent and the late fees are still being charged to you. You owe that money to the landlord. So the CDC order is not a forgiveness of rent. It just is a protection from being evicted. So it's not a free ride. You're still going to owe the money to the landlord. And you still must follow the lease and the other rules of the house. Like I said earlier, this protection under CDC is protection in evictions for non-payment of rent. So if your landlord says that he is trying to evict you because you have a pet that was never authorized, or you have people living with you that weren't authorized, or you've caused a disturbance too many times, those evictions will still go through because they're not non-payment. The last criteria says that on December 31st, 2020, the whole protection ends. And at that time, the landlord can say, okay, now you owe me for rent for however many months it's been. And if you don't pay the rent at that time, the landlord can start an eviction for non-payment of rent. In Florida, if you're being evicted, you get served court papers. And those court papers will tell you you have 5 business days to respond. That's an eviction. And if you get served that kind of paper, you want to get some legal advice on what to do. Just keep that in mind. So, how do you sign the declaration? The declaration is something that you sign under oath, and it has language that says you're swearing everything is true under penalty of perjury. And you're saying that you understand that if you're lying about any of the things in the declaration, you might be subject to some kind of fine or penalty. So it's a big deal. It's a very important thing to be sure that you fit all of those 7 categories. They're pretty easy for someone to fit. If you're somebody that isn't able to pay rent because of COVID, you probably are going to fit those 7 things. But just know that what you're signing is important and it has consequences. Once you've signed the declaration, you're going to deliver it to the landlord. Well, I'm getting ahead of myself. First, you're going to make copies because you're going to keep one for yourself and give one to the landlord. Very important, the CDC order will not help you if you don't give it to the landlord. It's great if you can get proof that you gave the declaration to the landlord. Sometimes a landlord will sign like a receipt that I got this. That's great. Some landlords won't cooperate with that, so maybe you could have a friend with you who could say, I saw her give the declaration to the landlord, something like that, because you want to have proof that you gave the declaration there. If you're already in an eviction, you want to file a copy of the CDC declaration with the clerk of the court. And that puts everybody on notice of your situation. Important to know. I said earlier that evictions are done by, you get served a paper that says you have 5 days to respond. And that's important because what I really want to emphasize here is that a landlord can't do things like lock you out, cut off the electricity or the water, can't remove your personal property from the unit. They have to go through an eviction because a landlord in Florida only gets possession back in one of 3 ways. An eviction, where a judge signs off on a judgment saying that the landlord is entitled to the eviction, or you voluntarily hand over the keys to the landlord, or you abandon the unit. So those are the only ways the landlord can take possession. Landlord can't do the lockouts or anything like that. If the landlord is trying to lock you out or has shut off the electric or water, you want to get some legal advice right away. If it's happening right then, if the landlord is at the door saying, I've got a locksmith here, I'm going to change the locks, whatever, you can call law enforcement because it's an illegal act for the landlord to be doing those things. If you need help with any of these things, these are the numbers where you can reach. The best one, of course, is us, because we love to do this. And we have the forms that you can use for this declaration. You don't have to write it from scratch. You could probably find them online, but we would be happy to write it up for you so that it's in proper format and that sort of thing. So feel free to call us, and we will be happy to help with that once you go through the eligibility process for us. The declaration form is something that is available online and through our office. Please make use of it. I want to thank you for participating. We have, if you have questions, and I really hope there are questions, you could use the chat box on the Zoom screen, and we'll try to answer as many of those as we can. I can answer questions about the CDC order or about the eviction procedures, whatever works for you. Lastly, I just want to acknowledge we are very fortunate at Legal Aid Service of Collier County to have great support in the community from our funders, and this is them. So let's open it up for questions. Okay, so the question is, do they have to be in communication with the landlord? They have to be in communication, but it has to be a written declaration. just telling him, hey, I can't pay the rent because COVID is a problem for me, or I've lost work or whatever, then that's not good enough. You got to put it in writing. Got to get the form, put it in writing. It's okay if if you fax it to the landlord, it's okay to send it by email. And in fact, those are great ways to do it, because then you have a record that you sent it to the person. I don't recommend that you do it through the mail, because that delays things by at least a few days. Better that you hand it to the landlord, or you send it in one of those alternate ways where you have some proof. But it must be in writing. One of the important things to know about an eviction is that it can have huge effects on your credit rating. You know this. Not only is an eviction terrible because it makes you have to leave the place where you're living, but it also means that it's on record that you were evicted. And I say that because what would be a great way to resolve these problems is to talk with the landlord to see if you can work out a deal. Will he be willing to take some back payments or work out a payment plan? So always think of some creative way to avoid the eviction. We have a question about whether the slides will be on the website. Yes, they will be. This whole presentation will be on the website for Legal Aid Service of Collier County. And our web address appears there. www.legalaid.org/Collier. I get the question about what happens just in a regular eviction from start to finish. So let me kind of run through that. The Florida law on landlord and tenant is set up to make evictions go through the system without too much delay. So it's a very fast process compared to other lawsuits. A landlord first has to give you a notice that he's ending the lease. Sometimes it's a 3-day notice, sometimes it's a 7-day notice. It can be different depending on the situation, but the landlord must first give you a notice. Once that notice expires, the landlord can file an eviction complaint in the county court. When the landlord does that, a summons will be issued, and either someone from the sheriff's department or a private process server will deliver the papers to you. Sometimes the service of the eviction summons and complaint is done by posting it on your door, or which means they would also get a copy in the mail, or they put it in your hands. Once you get served that paper, there are 5 business days to respond to what the landlord is asking for. And within that 5 days, you, the tenant, have the opportunity to file an answer, something that says why you shouldn't be evicted. You're also required to deposit the rent that you owe into the court within that 5 days, and then continuing whenever the rent becomes due. And that's where the CDC order can help you out. If you fit those criteria, then you can say, I can't pay the rent because of this situation. And so that should put a halt on things. But let's say that we're not working with the CDC. After that 5-day period is over, if you've not filed an answer, or you've not put rent into the court, or not filed the CDC order, the landlord can get a judgment of eviction against you. And you can do that on the 6th day. The judge will look at the paperwork, decide whether judgment should be entered, and especially if there's no rent money in the court registry, the judge is very likely to enter a judgment on that 6th day. When the judgment is entered, it allows the landlord to get a writ of possession from the clerk of the court. That writ of possession is served by someone at the sheriff's department, and it's delivered to you at the property. Once it's delivered, it gives you 24 hours to be out of the property. So you can see it's a very quick process. From the date that the landlord files the eviction until the date that the sheriff might be putting you out of the place, it could be as little as 2 weeks. That's not very common, but it could be as little as 2 weeks. We have a question, should clients that apply through a nonprofit or Collier Cares federal assistance program and are awaiting approval for the rental application also write this declaration? Yes, because the criteria does not say that you have to be successful in getting the assistance. It means you have to try, and there's no reason to wait to do the CDC declaration. The CDC declaration can be done whether it's before an eviction is filed or after the eviction is filed. So do it as soon as you can so that you get the protection of it fully. If you can do it before the eviction is ever filed, you might be able to avoid having anything show up on public records to show that there was an eviction going on. We have a question, is a text or email communication that has the 7 questions count as a valid declaration? Yes. There is some legal opinion that says it doesn't have to be in a perfect form, so doing an email that contains all that information is just as good. I don't recommend doing a text because you can't get all that information in the text. But what's critical is that it has to have, let me go back to, it has to have these magic words in it. And that's why it's good to get the form and use the form instead of trying to do something from scratch. If you don't have the magic language that you're certifying under penalty of perjury, or you understand that if you're not telling the truth, there could be penalties, then it might not count as a declaration. So it's best to get the form, use it, and then if you want to email it to the landlord, that's great. Again, a text, I don't think that's a good idea, because that would be one very long text if you were able to get it all in there. Any other questions? Please know that legal aid is here to help you. We look forward to helping as many people as we can through this very difficult time. It's certainly, you know, COVID presents so many different problems for us as a community. Housing is obviously critical. It's hard to stay safe and healthy if you don't have a roof over your head. We want to be sure that people get all the protections they're entitled to. So please reach out to legal aid. If we can be of assistance, we are more than happy to assist. I think that took care of all the questions. Hold on, we got another one. Oh, this is a great question. It goes back to where I was, the situation involving that term of tenancy. As you remember, I said the CDC order protects evictions based on non-payment of rent. If a landlord says, I'm not evicting because of non-payment of rent, I'm evicting because the term of tenancy has expired. So let's say that you are a month-to-month tenant. The landlord has given you a 15-day notice to leave at the end of the month. You don't leave, he files the eviction. That eviction on paper looks like it's not about not paying the rent. It's about just the term of the tenancy is over. Well, we try to fight those because it's a pretext. In a lot of the situations where somebody's on a month-to-month, you fall behind on the rent, the landlord might know that he's going to have a problem evicting you for non-payment of rent. So instead, he does a notice of termination for the end of the lease term. We try to argue that that's not the real reason. The real reason is about rent. And so the CDC order should protect the tenant in that situation. The person who submitted the question says that there's been a hearing on this already. The judge ruled in her favor, but now the landlord is trying to get it reconsidered by the judge. And my recommendation is that you want to get some legal help if you can for that hearing. But at the very least, you certainly want to go and say, look, the real reason he's evicting me is not about this end of the tenancy. It's because I haven't been able to pay rent. Any other questions? It has truly been a pleasure to do this for you. We are going to be hosting these Lunch Bunch webinars every Wednesday at noontime. Next week's topic will be foreclosures, and you're certainly welcome to join us then. You can go to our website to get more information about that presentation, but it's definitely going to be Wednesday at noon on foreclosures. And after that, there will be, the sessions will cover everything from small business formation, family law, domestic violence, children's rights, a lot of topics. So please join us every Wednesday if you can. And for now, thank you. Again, this is Kathy Lucrezzi, attorney at Legal Aid Service of Collier County. And thank you very much to my colleagues who have put this together. And thank you for attending. Have a good day.